Welcome to the Toolkit.law CLE webinar in the domestic violence section. Specifically, we're talking now about case intake and how to organize a case. We have two very experienced attorneys here in the United States who are joining us, Serena Hudson and Rob Musemeche. Serena, I understand you did the left side of the help sheet. Let's go ahead and start right there with your help sheet.
Yes, sir, absolutely. So when it comes to domestic violence cases, when it pertains to case intake and organizing your case, the first thing you want to do is make sure you have a consultation with your potential new client, whoever your client's going to be. You want to make sure that you get information, and this column in the green gives you an overview of what information you want to make sure you get, and we'll kind of go over it. So the first thing is obviously when you talk to this person, you want to make sure that they are in a safe location and can freely speak. And this is huge because you want to make sure that, especially when it comes to domestic violence, that you want to make sure that you're freely able to speak with your potential new client, who will be your client, and you want to make sure that moving forward, you obtain a safe email, phone number, and make sure that they have a device that they can utilize that on. Sometimes it comes up that you may even want to have a safety word. There have been cases where I've had to have a safety word with a client to make sure that they are not in a risk of danger, especially if you're, contacting them or if they're contacting you in a consultation. But hey, I want to, look at getting an attorney, but I'm not quite ready yet. I want to get my ducks in a row. What's happening? This is what's going on. This is what's going on. So you want to make sure you have that from there. And especially when it comes to domestic violence cases, you want to make sure that you have a safety plan in place. Where is it that they're going to stay? Who do they notify so that if somebody needs to know where they are, they know where the person knows where they are.
Now, Serena, obviously, no matter which country these legal professionals are watching us from, certainly it's important to get with the participants to get who the people are and what the facts are and to capture it
Absolutely.
accurately.
Absolutely. And so you want to make sure exactly, it's exactly what you said, Tom. You want to make sure you get the information and you want to get the facts and the people involved. Those who are subject to domestic violence, maybe, it may be tough to get the details from them beforehand. So you may want to be able to get the details from them and be able to follow up with them, but making sure definitely get to the people and what the facts are and even getting a timeline from them. When you are discussing or trying to figure out what kind of case it's going to be, you want to make sure that you get as much information from that person to determine what the case is. There's different cases, but some examples are whether it's a divorce, a suit affecting parent-child relationship,
Which of course, in where we're from in the United States, that's the fancy word for when you weren't married, but you had at least one child together, right?
exactly.
In
For
different countries will call it different things when there's children between two parties who were never married but are both the biological parents.
Yes, exactly. And it's good to know the differentiations between multiple types of cases because that goes straight to the heart of why we need to get the information that we need to see what kind of case we're going to have. And then you want to also get the information about the relationship between the parties. Because as you said, Tom, like in some countries or in different places, the relationship affects how the case is going to be handled. Here in the United States or in some states, you have to look at specifically what the dating relationship is between the parties because that may affect how you are able to, proceed with a case. Some cases may allow some relationships between the parties and some may not, or the type of cases based on the relationship of the parties. So
So
after
let's
you,
what about some investigating tips?
yes, so some good investigating tips is anytime you get on a case, you want to make sure you investigate it, especially when it comes to domestic violence. You want to get information on everything that you can. See if there's an investigation that's been done or a report that's been made. A lot of times in domestic violence cases, there may be a police report or children involved. There may be a CPS investigation. You want to make sure to get that information and get that information early on because it often takes a long time to get that information. But by getting that information, you can start doing your due diligence by reaching out to those people, getting the story of what happened, and seeing what reports and records there are.
Let's talk about case status and the different types of evidence a legal professional should think about.
Absolutely. So, when discussing with your potential new client or client, where you're at in the case is paramount because it really determines what you're going to do next. There's a big difference between starting a case off new getting things, getting the case started, or if a case has already been filed and let's say I'm coming on the case halfway through, I want to know if there's any hearings that's already been done or what pending settings there are, because that may help me determine what's already been done and what evidence I need to get. If there's pleadings in place, I need to get those. If there's evidence that's already been obtained, I need to make sure that I get it from my client's prior counsel or from the other side to utilize that for our case.
I loved how you talked about the different types of evidence, and one of the things on Toolkit.law, I almost call it our evidence suite, but in our creative suite, we have all the tools to edit the audio files, to edit the images, to edit the video files, and to deal with the documents as well. So obviously there are photos, there are videos, there are documents to deal with. What is your approach to when you think of the different types of evidence? Did I leave anything out?
No, I think you definitely covered it. Making sure that you ask for the evidence from the get-go is so important. It's so paramount because it may also change your strategy. For instance, you said looking at photos or PDFs or recordings. Well, if your client is telling you one thing and something else is happening in the recordings or photos, that may change your entire strategy. Let's also put this on the flip side of, let's say I'm representing somebody who's defending against a claim made against them about domestic violence. Well, isn't it important to get any recordings or photos to dispute that? That way, once you actually have that evidence, then you can utilize it. Because it's one thing to say something, but in order to actually get what you want, you're going to have to prove it and you're going to have to show it. And the
One
best
thing,
way to do that is to
one
get
thing,
that.
one thing I want to point out real quickly is in Toolkit.law, we have exhibit labeling. So if you ever need to quickly label an exhibit, we do the exhibit labeling right there, right in the software for people to
Oh,
use.
that's awesome.
Okay, finishing what you're talking about here, let's talk about skeletons because you have 1 minute left in this column.
Oh, perfect. Well, we're right on target. So anytime you are having your consultation with your potential new client, you always want to ask about their skeletons in the closet. There are, I like to say, three sides to every story: his, hers, and the truth. And so you really need to see from each perspective what's happening here. So what is it that they have against me? But what else? What do I have against them? And so you need to be able to address those skeletons of things that they could bring up because you want to be prepared for it.
Rob, you're obviously also an experienced family law attorney. I see in the next area that we're going to do, you're going to cover it regarding case intake with family violence, the applications in different types of cases. Let's go ahead and go over your column as we go to the second column.
Thank you, Tom. And, I think that domestic violence, I mean, from the beginning, of course, if you have a case that would come in with someone, let's just talk from the beginning. We're dealing with someone who has been harmed in the result of a violent act by someone that they're close to, right? So, I mean, I don't want to belittle the fact that you're dealing with people who know each other. This is not some random act of violence off the street. So we're dealing with people who are in a dating relationship. I don't care what jurisdiction you're in, whether you're in Texas, you're in Arizona, you're in any other country around the world. So someone who comes into my office who has been a victim of an act of violence by someone that they care about, someone that they're in a dating relationship, first of all, they're shattered. They are scared. They very well, as Serena pointed out, they are probably, very well, they could be in a hospital already before they came to you. So when I see someone of this nature, and I have in my past, and it's gotten worse, obviously, over the past several years for a lot of different reasons. One of the things that I want to think about is, what are the different reasons and what are the different areas of law that are going to be touched upon by what has happened to them? And so one of the things, obviously, one of the first things that I want to do is, is this person safe? I mean, who am I fighting for? Am I fighting for the victim of this family violence? Do I need immediately to help them maintain their safety? So in Texas, and I don't know necessarily what mechanisms there may be in the jurisdiction that other folks that are watching here, but we have protective orders. We can go to the court immediately and have some sort of an order issued under various statutes that we have here, try and obtain a court-ordered a distance for that perpetrator to stay away from my client. So that's one reason that I need to know some of the facts about what has happened. But I also need to be aware of the fact that, that some of these protective orders, if we can go in there without the other side even knowing about it, we call those ex parte, of course. They may be temporary in nature. So obviously, we're going to have some restrictions on how long those protections can last. But that's one of the first things that I'm going to think about in terms of the application of what how this family violence nature, the conduct that has happened, could be in play. And if I'm fighting for the other spouse, if I'm taking care of or protecting and fighting to zealously represent the alleged abuser, then I need to be aware that a protective order could have certain impacts on their freedoms. It could take away their rights. And so that's one of the applications and how that might affect. And there's a number of other things that are going to be applicable. So if they're married, then the imposition of a domestic violence finding is certainly in Texas and in many jurisdictions going to have a tremendous impact on the divorce case itself, or if they're married. If they're in a relationship where they have children, then the finding of a domestic violence by the court could have an impact on whether or not one of those parents is considered capable of maintaining a relationship with the children. So in my column, or in Serena and I have done these columns, these help sheets together, of course. But in the column that we have here with regard to application in different cases, you'll see we've gone down from protective order, we've gone down to divorce. Here in Texas specifically, if there's been an allegation of domestic violence within 2 years of the date of the allegation and we filing for divorce, that, for example, allows one spouse to seek, we call it spousal maintenance, but it's generally also known as alimony. In divorce cases, it can also, as I said here, can result in fault. It can be used as a reason for maintaining a claim for additional relief and division of the assets of the
Absolutely. And for those Toolkit.law users who are watching this from other countries, in the United States, you mentioned Texas. That's one of the states, or other countries may call it a province, but it's the state of Texas is where the two of you practice.
Correct. And I'm thinking that, I mean, domestic violence, again, that's why I wanted from the beginning to point out, we're talking about a relationship violence between people. And so at least we're talking about people who know each other, who are in a dating relationship or a long-term committed relationship, who are hurting one another. And generally it can be the female against the male. It can also be a same-sex couple here. But for the most part, we're talking about men hurting women. And in that regard, it can be fatal. I've represented a lot of women who are the victim of family violence. I've represented some gentlemen. These are different cases. When you first walk in the door, this is not the typical kind of divorce case where we have high net worth individuals who are fighting over who's going to keep the big house, or a contested custody case because dad wants more time with the children, or mom needs some additional support. These are delicate cases and they're extremely complicated, but they're also, they're emotionally volatile. And
Rob, I believe, as you pointed out in your help sheet, in many countries and in many jurisdictions, if there's a finding of family violence, it can affect who has the rights to make decisions regarding the children, can it?
Absolutely. And so here in our jurisdiction where Serena and I practice, a finding of family violence, for example, is in a child custody case, makes it such that that being joint parents is no longer a viable option. And so one parent the victim of that family violence can ask for a primary sole managing conservatorship of the children.
Rob, you have 1 minute left to finish this column, so let's move on to the torts claims.
Well, I also want to point out that family violence is, in fact, a form of twisted conduct, is what tort stands for, essentially, in the Latin frame. So if you are also a victim of family violence, then, of course, you have a claim for civil damages. There's going to be medical issues, medical damages. There's going to be, and that's why I put in here under personal injury. A civil lawsuit can be filed, at least we do this, if there is I always believe that there's always some sort of a tort in every divorce case, frankly. It's what I used to call it, and the way I like to practice. We file a claim for assault and for medical damages or for emotional distress and for potentially other damages to recover for the civil damages inside the divorce case itself. And that's why I've put in here under personal injury, because there are going to be actual civil damages in connection with the divorce, in connection with a family violence case.
Okay. I think you can still see the help sheet right on the screen. Am I showing it?
You are.
Perfect. So let's finish up with remedies and child protective services, or whatever they call it in their country where they're viewing this from.
Well, hopefully there are services available. Here, for example, in Texas, we have the Department of Family and Protective Services, and CPS, which is Children's Protective Services. The reason that I put down here in this category is because, interestingly enough, and I have a case or two now where family violence between the spouses, just one spouse against the other, has actually been found that it could impact this parent's ability to actually be considered whether they're fit for maintaining the possession of their own children. So the state has come in and said, if you have a situation where two parents are fighting and hitting each other, they're not even hitting the children. In my particular situation, the case I'm dealing with, the state has said that parents hitting each other poses itself a danger to the children, even if the children are not the victims themselves of that family violence.
Absolutely. Rob, you're out of time for your column. We're switching now to the third column, back to Serena's column. Let's talk about evidence and exhibits.
Absolutely. So when you're looking at your different type of cases, as Rob was saying, you always want to look at, okay, what kind of evidence do I have? What kind of evidence do I need? And what exhibits am I going to be looking at? And the first thing that's going to come to mind is obviously testimony. Testimony from your victim, testimony from your alleged perpetrator. A lot of times there's going to be instances where victims who are, succumb to domestic violence don't instinctively reach for the phone and record. So sometimes the only thing you have is just the he said, she said, or she said, he said scenario. So in order to bolster that testimony and have that good evidence for your client, you want to make sure that you can bolster that testimony versus, just the what each other says, but by giving examples. Give examples, describe it to me, read it to me like a book. Put the judge or the other person, the fact finder, into their head and say, oh my gosh, I can see this basically by what they said. But it's not always ideal to have just testimony, but sometimes that's all you have. Hopefully in other instances, you're going to have good evidence of what we were talking about earlier with photos. Gather photos of proof. If someone still has physical evidence, have them take photos of it. Marks, bruises, lacerations, that kind of thing. Sometimes there's also abuse that's not just physical. It could be sexual, it could be financial. It could be other instances. So if it's, for example, financial abuse, if someone's draining the account, leaving the other side with nothing, you want to be able to get that proof to show that. Okay, what are the pictures? What pictures do we have of screenshots of draining the account? And if someone who is defending against these claims, ask them to get photos too of surrounding. Who is it that, if the one person claims, oh, on this date, this person hit me. Well, if there's a photo that's showing that the person is somewhere else, that's really helpful for us to have. And obviously, besides photos, you can get audio and voice recordings, or audio and video recordings. Something that's really important to distinguish in our jurisdiction and maybe that may be not the case in other ones, is that in Texas, recording is a one-party state. You have the ability to record a conversation without letting the other side know, as long as you are a part of that conversation. So it's a good tool to be able to have that as evidence and proof of your claim. And then besides that, audio, voice recordings, photos, things like that. There may be other times where there's other documents. You know,
I want to point out something really quick. So
sure,
on Toolkit.law in our video tool, sometimes in family law cases, people just post stupid things online, right?
yes, all the time.
So if you go to Toolkit.law, we have a YouTube and a Facebook and an Instagram video downloader. So it instantly downloads it. So if you go to Toolkit.law, go to the Creative Suite and go under Audio Tools, the audio editor and the video editor. If you need to increase volume, if you need to crop a photo or a video, anything with the dealing with the audio or the video, or to download off social media, and it'll download into any of about a dozen different file formats. Let's talk about the other documents that you were just mentioning.
Yeah, other documents that you were just talking about, it could be social media posts or emails or text messages. You can absolutely get those. I'm kind of going down to that next one, then I'll go back up to other documents. But since you were just there, I mean, I think a really good thing to get off like from the get-go is text messages because it provides a really good insight to people's relationship. And so you can get a complete set with an iPhone. You can do it through iMazing, or an Android. You can do it through Doctor Phone. But regardless of what, emails, text messages, or social media postings that Tom just said, what you want to make sure you get is making sure those documents were legally obtained. Asking your client where they got them, or ask the witness where they got them, because your evidence is as good as how it was legally obtained. If it was not legally obtained, then you're also putting your client in a really bad position. So making sure that, okay, if they got these, social media postings, obviously you're probably getting it from social media. So it's going to be public and fine. But if you're getting, emails or text messages from that person's phone, you want to make sure that they actually were able to get them in a legal way instead of, wiretapping or things like that.
You've got about 2 minutes left for your column.
Okay. Great. So we'll move on to witness statements, kind of like testimony. You want to get some statements from witnesses. They can be used in a multitude of ways, using them to impeach or using it for using against the person. You also want to make sure that you get other documents and evidence as well. Enforcement investigations, we talked a little bit about before, and what Rob was talking about, that CPS reports. You also, Rob also mentioned that there's going to be times where they have to go to the hospital. So there's going to be medical records. And you want to make sure that you can get those and not only get them, but also know how to be able to use them. It's one thing to have them, but you got to know how to use them, know how to authenticate it, and know the predicate of it so you can actually get them into evidence to use them.
And of course, in North America, we refer to it as predicates, the legal rules by which to enter into the evidence. But how critical it is to absolutely have your predicates printed out for you, so that when you go into that evidence and you get an objection from the other side, you're able to get it through.
Absolutely. It's crucial because you're as good as the piece of paper that you've got unless it's admitted into evidence. If you can't have it right there, of how, as you just said, Tom, if you don't have it right there and the other side can kind of catch you off your feet and figure out a way to keep it out. So you want to make sure that you can get it in so the court can utilize it.
Rob, let's now talk about parties and witnesses as we finalize this help sheet.
Yeah, thank you, Tom. I still want to keep coming back to again and again. I mean, when someone comes in my office and they've been the victim of family violence, it my eyes open up more so than in almost anything else. Because it's important, and that's why I said, who are you fighting for, and who are you fighting against? I've represented gentlemen who've been accused of shooting their wives. The allegation is of course denied, but again, the bottom line is I've also represented far more oftentimes the wife who is coming in and scared, and the allegations are that her husband is hurting her and pushing her and slapping her, and there's so I mean the bottom line is you need to build a plan. What is your strategy? How are you going to go about pursuing this? You have a victim and you have an alleged aggressor in each of these cases. So if your client is the victim, then I want to go forward, and I need to be sure that I understand the strengths that my client has. I want to know what firsthand knowledge they're going to be able to provide to me for direct testimony. I need to know what weaknesses that they're going to have. I need to know if they have emotional volatility, if there's going to be any kind of allegations of bias, if there's going to have any kind of and the same is true then as well. There's going to be some attacks potentially on their prior conduct that we need to be concerned about or aware of. Oftentimes, and I think that Serena touched on it from the very beginning in the initial intake, what's the information that they can provide? So that's one of the parties. The other
and finding out if your own client has a criminal background. I'll never forget. It happened about a year and a half ago. Is it a case? Guy said he'd never been convicted of anything. He had a 14-page rap sheet.
Gotta know
14
about those
pages.
skeletons.
Got
Gotta know the skeletons.
Yep, the skeletons. Absolutely. Continue, Rob.
Well, yeah, and I had a client who we were about to find out and we were going to go after because the locals, the CPS, told me that the other party was involved and that there were some concerns about whether that person had was a fit parent, and I was able to get some information about why they could concerned about that, and it turned out that there was some allegations of drug use, and I said, that's fantastic. We're going to use that. And my client said, well, yeah, I can prove that there's drug use involved. And I said, how is that? He said, well, because we did it together. It's like, well, then, okay. We can't do drug testing in that case because he was dirty 2 weeks earlier. Anyway, you've got to find these things out. So the alleged aggressor and the abuser, they're going to have strengths and weaknesses too. They're going to have, you want to find out what contradicting information they may have. They're going to contradict themselves. You find out whether they said anything to the police, if there was a police report issued or some other law enforcement came out to investigate the scene. Did this alleged abuser say anything? Did he try to defend himself, or did he admit, yeah, I pushed her, but I didn't push her that hard. Oh, we were fighting. And so she told me that she wouldn't leave. And so I just kind of set her aside. I pushed her out of the way. Well, those are, at least in my jurisdiction here, any kind of offensive touching that causes pain is the definition of assault, and that's the definition of family violence. So let's find out whether or not later on in the courthouse he wants to dispute that. They even said those things. One of the other columns we've got down here are supportive witnesses, and we still need to find out whether or not there's going to be bias with regard to these folks. What is their motive? Are they family members? Are they just trying to protect them? Our judges are pretty smart and savvy. They've seen these things in larger jurisdictions. Family violence cases are sadly so common that there's a lot of opportunity for jurists to see witnesses who are obviously there just to help their family and friends, so they can see through whether there's a.
Rob, you have 2 minutes left to wrap up this column.
2 minutes. I need more than 2 minutes, Tom. All right, so let's go to law enforcement and other kinds of first responders. Bottom line is that these guys, as I put in here, are going to be on the scene. They're going to have a lot of firsthand knowledge. Experts, let's be careful about experts. Because expert witnesses, these doctors, nurses, and counselors and so forth, I want to be careful before I get in the ring with somebody like that, because unless you've done this a lot, unless you know and how to really cross-examine them, or unless they're on your side, be careful that you don't step into something where you are going to be asking a question that you don't know the answer to. On the other hand, these folks, first responders, the doctors, the psychologists, if they have special skill and they've done this a lot and they've seen this a lot, then they're going to be probably just as frustrated and angry at watching all of this violence, and will probably, if you're representing the victim, and you talk to them ahead of time, they're probably going to be sympathetic to your client. Finally, I wanted to go down and talk about the if I can, real briefly, that family violence intersects so many different disciplines. There's criminal aspects to it. There's family law aspects to it. There could be immigration law aspects to it. And so I think it's important that when you get one of these cases, that you have the ability to reach co-counsel, or at least tell your client to reach out to co-counsel in different disciplines, to make sure that there's not a plea bargain agreement that's accidentally entered into in the criminal case that could impact either their immigration status or their family law case.
I have a case now where it's impacting a probate case. And you certainly talked about civil tort law.
Exactly.
Not to mention child welfare law. Well, that concludes our domestic violence presentation on case intake and organization. I'd like to thank Serena Hudson and for Rob Musemeche for joining us. You can see their contact information on the bottom of the screen, and we're also featured in the video. Thank you very much.
My pleasure.